Prenuptial agreements and postnuptial agreements are impactful to property division. So a court is going to honor a prenuptial agreement or a postnuptial agreement unless it's considered unconscionable. And that is based upon the facts of the circumstances. An unconscionable decision or an unconscionable agreement means nobody in their right mind would have signed the agreement, or nobody could have possibly foreseen the circumstances that we're in right now. However, one of the factors that the court will consider is the agreements of the parties. So if you guys have an agreement and you've written that down, a court is going to honor that agreement unless there's a reason not to. So if you have a valid prenup, chances are it's going to impact how your divorce gets done. If you have a valid postnup, chances are it's going to impact how property is divided in your situation. Prenups can be challenged or invalidated on a variety of reasons. Some of them are going to be the circumstances surrounding the signing. Some are going to be the impact of that. So the biggest thing when it comes to prenups, so when people come to me and ask me to do a prenup, the first thing I'm going to ask is when the wedding is scheduled. If somebody tells me it's scheduled within the next few weeks, I'm going to tell them that I don't think it's a good idea to do the prenup right now. The thing about any sort of agreement that you have is you want people to come to the table and have an understanding, an agreement in plenty of time so that they can make changes or negotiate in good faith. However, if you've got a full wedding hall when you got hundreds of people scheduled to come in and somebody's presenting a prenuptial agreement, it's really difficult to back out now because you kind of feel those pressures of society and familiar pressures of, I don't want to cause heartache or problems to people. So the surrounding circumstances of how that prenup was signed and what was gone into it is going to impact it. Also, the disclosures are going to be a huge impact on whether a prenup is going to be validated or not. In other words, what was disclosed when people put this together? Any sort of agreement, you want to make sure people are going into it eyes wide open. In other words, did we share what they had? Did we share what was out there? Because if they didn't really know what they were signing, how can you say they reached an agreement that was done in good faith? The next way to invalidate an agreement might be the circumstances as they are today. So for example, maybe people signed this agreement when they were completely healthy, able to work, and now things have changed significantly. Maybe a medical injury happened, something happened, and they're no longer in that same state of mind. A court may look at it and say, as we're applying it, I'm not going to go forward because it would be unconscionable under these circumstances. The important thing is make sure that you get with an attorney that understands prenuptial agreements and how they're enforced throughout the courts before you file anything. Financial mediation is an option if both parties want to participate in it. In order for mediation to work, both parties need to have similar information, and the mediator has to be able to talk shop, if you will, with the persons involved. In other words, mediation is very common when it comes to children because the parties understand their kids. The mediator probably already knows about the decisions that have to go into it, the parenting plans. Those sort of situations are common for a mediator to have. When it comes to financial mediation, you need to make sure that your mediator understands what's being mediated, because if they don't understand the information, they can't really help with making sure that both parties understand the agreement. The goal of mediation is to have people come out with a full understanding and a complete agreement. If one side has superior information and the other has inferior information, it's not going to be a valid agreement. And in that situation, financial mediation may not work. When it comes to asset division, either you're going to agree or you're going to allow the judge to make a decision. It's that simple. Now, as you go through the process, it feels as though it's not. But when you keep that principle in mind, you'll understand that when you have an idea of how you think things should be divided, you have to recognize your spouse doesn't have to agree, and that's okay. There's a process and there are things that we can go through to try and bridge that gap and ultimately get you through this process and get you towards an agreement. But if we do everything we can to try and get you to an agreement and we still can't get there, ultimately that's what the judges are there for. It will be up to you and your attorneys to put together your case, gather your evidence, put together everything that you want to support your position, and try and convince the judge. That might mean experts come in, it might mean testimony, it might mean a lot of documents, but at the end of the day, you put on your case and you let the judge make a decision.